All right. All right, we're live. So my name is Chris Berry, certified law attorney and certified financial planner with Castle Wealth Group. And we do these weekly wisdom webinars just about every week. We won't be doing this next week because our office will be closed for the holidays, but we'll start again in January. So what we do on these, there's nothing prepared. It's all really just answering whatever questions that have either been submitted previously or submitted while we're chatting. So if you do have a question, feel free to put it in the Q&A. Otherwise, I'll go ahead and get started. And before I do, we always start with positive focus, just something positive that happened over the last week or so. And best thing for me was I took my 10-year-old for her birthday to Disney World. So surprised her by waking her up at 5 in the morning and saying, hey, we're going to Disney World. And we got on a flight and headed down to Disney World and had an amazing time. It was great to create those memories with her. So that was pretty darn cool. That's probably one of my favorite positive focuses. All right, with that, we'll go ahead and get started, get into this. Let me go ahead and share my screen. And let's hit this button, this button, this button, and we should be live. All right. So keep in mind, this is general information. And really, I only have one question that was submitted ahead of time. So if you do have any questions, please put it in the Q&A. But it is a juicy question. How do you go about funding a trust? We're married with kids and been told not to fund retirement accounts to the trust. All right. So think of a trust, and really there's two types of trusts in our office. We have what we call revocable living trusts, and then we have castle trusts. Both are good, both avoid probate, but the castle trust builds in asset protection, where whatever we put inside of the trust is protected from creditors, but also it builds in protections against nursing home in that Medicaid or nursing home spend down. So it's an asset protection trust. So we have the revocable trust versus a castle trust. The revocable trust more is about like what happens when you pass away. The castle trust does that, but then also builds in the asset protection. And you'll see why that's important when we talk about funding a trust. And this is one of the biggest problems that we've seen when clients have an existing estate plan is that if they do have a trust, it's not funded properly. So when we talk about funding the trust, what we're talking about is getting assets or pointing assets to the trust. And there's two different ways that we can do that. One is changing beneficiaries. So we change the beneficiary to point to the trust. At banks, you might hear this called payable on death or transfer on death, but this is like your life insurance, your 401ks, your IRAs. We can name the trust as a beneficiary. The second way that we have assets point to the trust is ownership. We can have the trust own that asset, like own a piece of real estate. We can have a trust own an investment account, own life insurance, own a checking account, own businesses. So typically when we're changing ownership, that's when we're putting it inside of the castle trust. So we'll make the trust the owner of your home now. If you have a business, we will assign that business to the trust. If you have a rental property inside of an LLC, we'll assign the LLC to the trust, which gets the rental property into the trust. We can have investment accounts and checking accounts, savings accounts, all owned by the trust. So when we talk about funding the trust, when we have a castle trust, which is the asset protection trust, we want the trust the owner of as many accounts as possible. Where sometimes we run into issues is with regards to IRAs, because you have to be the owner of the IRA. A trust cannot be the owner of an IRA or 401k. But what we do is typically with those retirement accounts, which we call qualified accounts. So these are qualified accounts. There's some type of tax qualification like IRA, 401k, 403b. Typically, you would be the owner. So the owner is you. Typically so you're the owner, and then the primary beneficiary. So beneficiary one, typically if you're married, which in this question they are, would be a spouse. So they can do what's called a spousal rollover. And then if we have a trust, then we would name the trust as the second beneficiary behind the spouse. So that's how we handle qualified accounts like IRAs, 401ks, 403bs, even Roths are what we call qualified accounts. Then we have non-qualified accounts, which is basically everything else. So non-qualified accounts would be things like checking accounts, savings accounts, brokerage accounts, even like real estate. And so for these, if we are doing a castle trust, so if we are doing the castle trust, then as much of these as possible, we want the trust as the owner, okay? If we're doing it, and then we don't have to worry about the beneficiaries because it's already in the trust. If we're doing a revocable living trust, then typically what we're naming, you can remain the owner of it because again, a revocable living trust really offers you no asset protection, no benefit while you're alive. It's more about what happens when you pass away. But typically with these non-qualified assets, we'll name the trust as the primary beneficiary. And you might be asking, well, why not the spouse? Well, the spouse is the primary beneficiary of the trust. Like if you're a married couple and one spouse passes away, think of a trust like a suitcase, the surviving spouse is still holding on to that suitcase. Now, if we're in a situation where one spouse passes away, the other spouse is incapacitated, and we name that spouse outright as a beneficiary, then we might have to create a guardianship or conservatorship to manage that money. But by us naming the trust as a beneficiary, like let's say we have a life insurance policy, one spouse passes away, surviving spouse is incapacitated, by us naming the trust as the beneficiary, now that successor trustee can manage the money for the benefit of that surviving incapacitated spouse. And getting back to the qualified accounts, the reason we name spouse first there is they can do a spousal rollover where now that qualified account becomes theirs. And why this is important is because let's say husband and wife, husband passes away at age 75, they were taking out required minimum distributions because once you turn 72, you have to take money out of those accounts. But let's say wife is only 68. If she were to inherit it as a inherited IRA, not a spousal rollover, these are kind of terms of art. If she were to inherit that as someone other than a spouse, she'd have to take out RMDs over a period of 10 years, pay the taxes over 10 years. But because she can do a spousal rollover, when you name a spouse, so you have named the spouse as the primary beneficiary of that retirement account, they can do a spousal rollover where now that surviving spouse, that IRA becomes their IRA and it follows their age and life expectancy in terms of required minimum distributions. So in that situation where we have a 75-year-old leaving it to a 68-year-old, that 68-year-old does not have to take out any required minimum distributions. She'd have to wait until age 72 if she wanted to. And then we name the trust as the contingent beneficiary instead of the kids, because that's where all the protection's built in, like especially if we're building in a divorce and creditor and we want to make sure the money stays in the bloodline. The only way that we can effectively do that is by setting up the trust correctly and naming the trust as the beneficiary of those retirement accounts. Now, I've seen this so many times and it's one of the most frustrating things is just the confusion around this. Like you talk to some advisors and even some CPAs, they say don't name the trust as a beneficiary because they're concerned it won't qualify for what's called a designated beneficiary, which means that all the taxes would have to be paid within 5 years. Well, understand, due to the Secure Act, the maximum that we can stretch out those taxes when you inherit the IRA, so not under a spousal rollover, but under an inherited IRA, the max you can stretch it now is 10 years, whether you name the kid individually or you name the trust. And then if you set up the trust properly, which all of our trusts do, they can still maintain that 10-year stretch. So we are almost always naming the trust as the contingent beneficiary instead of the kids, because you have all the tax advantages of that 10-year stretch, but now we can build in the asset protection. So I've had to go to bed with other advisors and CPAs, and at the end of the day, once we go over it, 99 times out of 100, we're naming the trust as the beneficiary, contingent beneficiary of those qualified accounts. So in terms of estate planning, the first step is to set up the trust. And a lot of times people have a trust versus a will because of the various benefits. But then equally important is the funding of the trust. And this is something that we take very seriously, where we're working with clients and nagging them, because we can't do it for our clients unless we're actually managing the accounts. Like, I can't go into your bank and change a beneficiary. We can give you instructions on how to do it, but we can't do that. So, but we work hand in hand with our clients to make sure everything gets funded properly. But yeah, so it's just going through that list, those lists of assets of, okay, my checking account, that should be payable on death to the trust. My savings account, payable on death to the trust. Those are non-qualified accounts. I have a brokerage account. Well, if I have a castle trust, the trust should be the owner. If it's a revocable trust, the trust should be the beneficiary. I have real estate. If it's a castle trust, we're going to name the trust as the owner by doing a new deed. If it's a revocable living trust, then we're going to use a tool called a ladybird deed. A ladybird deed, which is a type of deed that says the home is in your name while you're alive and well, but then upon death, it flows into the revocable living trust. It's like a beneficiary designation for real estate. And if you have multiple pieces of real estate and they're in your name, then we would do multiple ladybird deeds. If you have multiple pieces of real estate, typically what we actually recommend is setting up an LLC or multiple LLCs to make sure that you can protect the liability on those different accounts or those different assets. Because real estate, it's like a hot asset. You never know when something might happen, the slip and fall. And so you don't want that to bleed over into your assets if there is any type of liability. So a lot of times if there's multiple pieces of real estate, we would do deed it directly to an LLC and then assign the LLC to the trust. But if it's primary residence or there isn't a liability concerns, then we'd just do multiple ladybird deeds, which are basically beneficiary designations for your home. So yeah, so in terms of funding the trust or estate planning, like the first step is to set up the trust. Second step is to make sure it's funded. And how we fund the trust depends on what type of trust we're doing. If we're doing a castle trust, then we want the trust to be the owner of as much as possible. If we're doing a revocable living trust, whether a basic revocable living trust or a legacy trust, then typically we're naming spouse first for qualified accounts, which are your IRAs, 401ks, 403bs, anything like TIA, CREF. All of those are qualified accounts. Your employer sponsored plans, those are qualified accounts. So we would name spouse first and then trust for either a castle or a revocable trust. And then any non-qualified accounts, if it's a revocable trust, we're naming the trust as the primary beneficiary or payable on death. Similarly with the real estate, if we're doing a castle trust, then we try to get as much as we can owned by the trust, where the brokerage account is owned by the trust. The real estate is owned by the trust. If there's a business, it's owned by the trust. So how do you go about funding the trust? So once the trust is set up, then it's circling back with the different financial institutions and recording the deeds to make sure that everything is pointing correctly to the trust. If it's accounts that we're managing, obviously we take care of that for you, but we can't go into the bank and change beneficiaries for you. And so that's why we have a bigger team to help our clients kind of navigate that. And as you go about funding the trust, you're going to hear all kinds of weird things, especially at the banks. Because you go in there one day, you talk to someone, you go in there the next day, they're going to tell you something different. So we just tell our clients, if you hear anything other than what we're recommending, reach out to us to make sure we're all on the same page. And again, one of my favorite pastimes is when I go into the bank, and I like my bank, but whenever I go to the bank, I kind of listen to just all the bad legal advice that they give. Oh yeah, just add your kids' joint to your accounts. I'm like, oh my God, no. Like I want to just intervene and rescue some of these people. But yeah, it's a necessary evil. Like you have to get the trust funded. It's one thing to have a trust, but it's not worth the paper it's printed on if it's not funded correctly. So, all right. So hopefully that was helpful in terms of funding the trust. Now, let me see if there's any questions coming in. All right. Looks like I don't have anything. All right. So I want to thank everyone. It's been a great year. Look forward to seeing you in January. We'll be off next year. Merry Christmas, Happy Holidays, Happy New Year. Look forward to seeing everyone in 2023. Make it a great rest of your year and see you again in January. Thank you so much. Merry Christmas, Happy New Year. Yep, thanks.